Ebusuafo memo bibia kwaba eba Melodies TV so. Melodies ebusuani ba ko a oye legal brain what you say. Senior lawyers no mo from ho the learned omo from ho the learned colleagues. We say ye no yen call law school yen free yen learned but omo no they call themselves learned colleagues. Inti Melodies ebusuani ba ko a ono nso e was field name law. What you say? Ababetro a very nice article. Na your friend Daniel Gidi. Now, article now all trono. It is about the Chairman Wontumi case. Now, who named the ACR? Chairman Wontumi lawyer. Lawyer attaching. Asanso atro akwa koma court. Say Chairman Wontumi case na judge no we delay already no for about some weeks no. Judge no so entwentwen ne judgment so na wono Chairman Wontumi lawyer no ohun de say Ghana mra baabi no onti ase nti Supreme Court emma embra no understanding ansana judge no wato aso aba man ruling na nini na no yemu bi ye believe say it's just a bit to delay the ruling of the Samurai Boy case what you say because apparently maybe they know say bia enko Chairman Wontumi a square sani ebekano entino your brother ababetro a legal article on this, and this is if you follow me you know that this is one of the things I like very much. Say in same year na nkrofo was our sector no na me person mo tro omo adwen ni na ye hu de eko nti ye pese ye read ana ye read na ye hwe nsemo a your brother ede etodwa and now first time we have subscribe and click the notification bell on so we hear our latest news be about Sabekan. This video is kindly sponsored by Corporate Logistica. Omo ye vehicle management company e Ghana ha nkrofo bebre na no dodo na no eya na omo toka na omo pese car no obi di adwuma mo a eya no mutumi nteka because of issues bebre either say car no sika no de be maintenance ana we nya driver pa insensem bebre mesraw otoka na fa car ne she Corporate Logistic ansa ono ankasa wo drivers no ebetwi car no ono ankasa betua the maintenance on the car insurance wo car ne ho ono abetua na wo car ne ye ode no every month obema waketua 2 times inti dia beto car ne bia no dia ode no ane se ode car mo na ye ma waketua na ode ate wo car na osanso dia to car foforo sa fra 059 8022033 One Corporate Logistic and Trade Common. Oyo ba na onim se ni twi cars akesie te se ahwea cars akesie ni cargo vehicles akesie afre Corporate Logistica na omone wo enye adwuma. Now yankenkan yenwai article no. Now also legal question. Also a judge has set a date to deliver judgment in a criminal case involving a politically exposed person. The Republic and the accused have both closed their respective cases, and the matter has been adjourned for judgment. Before the judgment is delivered, counsel for the accused withdraws from the case without filing his written closing address. A new lawyer enters appearance, requests time to steady the record, and file a written address, and a trial judge grants the request, fixing a new date for judgment. 5 days before the scheduled judgment, the new defense counsel files his written address and simultaneously applies to the trial court to suspend the delivery of judgment on the ground that he intends to invoke the interpretative jurisdiction of the Supreme Court under Article 130 of the 1992 Constitution in respect of issues which he claims require constitutional interpretation. In these circumstances, is the trial judge bound to suspend or stay the proceedings merely because counsel alleges that constitutional issues have arisen? What is the position of Ghanaian constitutional law and criminal procedure? Very, very good question. Inti asemu a yebra epese kan say Chairman Wontumi case no ekoso omodi asem na wie aka se Chairman Wontumi lawyer the old lawyer no ebe file ade bia ye frɛ no ne written statement say obetro ebia conclusion and a summary Oba betro na wasi case no ndibium new lawyer ba lawyer ne say an onim case ne ho hwe ma ne mre judge ma ne mre lawyer na kwa control ne conclusion otro wie ye no ono nso aba be ka treja asem mesrew issues bi aba me pese ye ko Supreme Court na Supreme Court ekoko tremu enti answer na Supreme Court ebe tremu na before Supreme Court inyan tremu dia na wo judge no me ndi asem no twen na Supreme Court in tremu wi answer na waba be di case no enti ye bra ebisa se ede na wo se judge ne ye Ghana mra no ema judge ne kwan se wontie Chairman Wontumi a lawyer no ana judge ne nkoso nye de no judge ne pe answer any. Also, the legal position under the Constitution of the Republic of Ghana 1992 is that a trial judge is not automatically obliged to suspend proceedings or withdraw a scheduled judgment, mainly because counsel alleges that constitutional issues have arisen or expresses an intention to invoke the interpretative jurisdiction of the Supreme Court. Inti yebra answer woman say Ghana mrano and judge say by force se case koso na obi say judge na ntwentwen so ne mfanko Supreme Court na Supreme Court emetre mu ansa nti wo judge twentwen so Ghana mbra nhye judge no say judge ne nyesa ade no Ghana mbra nhye judge no say by force yede akọ Supreme Court nti twen main rule dabi. Also, the law has consistently distinguished between a mere allegation of a constitutional issue and the actual existence of a genuine, substantial, and necessary constitutional question requiring interpretation by the Supreme Court. Consequently, the filing of an application for constitutional interpretation without more does not by itself divest the trial court of jurisdiction or compel an adjournment of judgment. The judge must first satisfy himself that the constitutional issue genuinely arises within the meaning of Article 130 of the Constitution before the mandatory referral procedure becomes applicable. The governing constitutional provision is Article 132 of the 1992 Constitution, which provides that where an issue relating to the interpretation or enforcement of the Constitution arises in proceedings before any court other than the Supreme Court, that court shall stay the proceedings and refer the question of law to the Supreme Court for determination, after which it shall dispose of the matter in accordance with the Supreme Court's decision. The significance of this provision lies in the expression where an issue arises. The Constitution does not provide that proceedings must automatically be suspended whenever a party merely asserts the constitutional interpretation, a party merely asserts that constitutional interpretation is required. Rather, the issue must genuinely arise from the facts and legal questions before the court. Osi Oshe Chairman Wontumi lawyer no o based on Article 132. 132 eso. Now, Article 132 of the 1992 Constitution, asem can say yes. Say ye di asem na ye di no. Constitutional issue be arise wa asem ni mu a. E was ye ko Supreme Court. Na was a judge na twen asem ne so. Ti ko Supreme Court na Supreme Court ema ruling we are. E was a judge no occur with the Supreme Court ruling. But you see, a different. Or say where an issue arises. Se embra ye di case no na asem no epie mu dia sa na ebeye. But Osha Chairman Wontumi case na embra ye di case no sa constitutional issue no arise. Ye di case ne wi a ye be ma judgment no e na oba be claim say you have a constitutional issue with the case. Ye di case ne wi. And so the Constitution does not allow say was say judge no odi Chairman Wontumi lawyer na asem ne so. Basically, what our brother, the Ebra Air Canon. Or see, over the years, the Supreme Court has carefully developed the jurisprudence surrounding Article 130. The court has consistently held that constitutional interpretation should not be invoked merely because a litigant uses constitutional language or cites provisions of the Constitution. So I say for so many years, Supreme Court in Husadi, no. Say lawyers be briohena se na asem no se ne ekono endi mwana na wa hye dey raise Article 130 no into Supreme Court judges na nkasa no omo ama rulings be bria etia sa de no Se men sorry kekenka se ane asem ne nko ntia we nti no ube rezi constitutional de dabi yenso so also. Or say the issue must be substantial, necessary for the determination of the dispute, incapable of being resolved through the ordinary application of settled constitutional principles or existing statutory law. Where the matter before the trial court merely involves applying an already clear constitutional provision, there is no obligation to refer the matter to the Supreme Court. In other words, the law distinguishes between constitutional interpretation and the ordinary application of constitutional provisions, and only the former falls within Article 132. This distinction serves an important constitutional purpose. If every allegation of constitutional interpretation automatically halted proceedings, litigants would easily frustrate the administration of justice simply by raising constitutional objections whenever judgment became imminent. Such an interpretation would undermine the efficient administration of justice. And I agree with what our brother is saying. I'll say there is a clear difference. Yen sorry keke, enkasa asem we makokot medi asem na judge eba be ma judgment. Asem ne nyame de. Enti min konko raise issue kra se Supreme Court emma interpretation on a certain article. Dabi, because in the thinking of Supreme Court judges, no, among so so because ye nimni ekoko so Ghana has say no, your judges system no ebe chaotic. Obia be di na asem ewie on raise issue. Or when I say judge the judgment say, but because obia senya asem no call court bia no, obia nim, so be we new nim. Ofili, it was when I say asem no want to be ending ye no when I say case na say equate ya nepe. Or say make Supreme Court for interpretation just because of a so delay. Obo say arm robber. Me na me amede me example e ka ho. Obi am robber. Ye di na asem we for so many years. Ye raise issue. Judge amadate obema judgment a ebi am robber ne hu say asem no ebe kwetia no. Obo say or say judge me ma we no na me kra no me pese me ko Supreme Court for interpretation. Dabi ye nya ne sa ne ye ne sa dia na ka Ghana ha say embra anya edwuma biom. Obi eni obe penese ye nche no. Obi eni obe chi no my way mu because obi abedwane akọ Supreme Court for interpretation. And I agree with what our brother is saying. He goes on to say, undermine the efficiency administration of justice, encourage abuse of court process, and permit endless delays in criminal and civil proceedings. Also, the Supreme Court has therefore repeatedly warned lower courts against referring issues that merely appear constitutional in language but are, in substance, ordinary questions of law. At the same time, the court has cautioned lower courts not to usurp the exclusive interpretative jurisdiction of the Supreme Court where a genuine constitutional issue actually arises. The trial judge must therefore exercise careful judicial discretion in determining whether the threshold established under Article 130 has truly been satisfied. As applying these principles to the present fact, it is significant that the Republic had closed its case. The accused had also closed his defense, and the court had already fixed a date for judgment. Inti yebra someone can say Supreme Court ama warning. Say adeya Chairman Wontumi a lawyer peso ye no. Ye ni kwansi ye so. And then Supreme Court has answer catch other courts no, lower courts no say, yes, obinso was genuine issue a monfambra. What you say? Inti yebra area mu na or tre mu say or apply principles to the present fact now. In the first place, as I told you, Chairman Wontumi case no we di ewie. Or the witnesses aba. Asem you obeken bia waka. Owo issue pan anka sa time ne nanka also raising the issue no. Now so when raise judge ama date so be ma judgment. Wasre so ontwin ko ni watwe akọ nim. Afei oba be ma judgment a. Afei na obe raise issue. Embra ya ka asem na wie. Dabi. Inti yebra eto aso a. The withdrawal of previous defense counsel did not reopen the trial or invalidate the proceedings. The incoming lawyer was afforded a fair opportunity to study the record and file a written address, thereby satisfying the demands of procedural fairness. Once that opportunity had been granted and exercised, the case was once again ripe for judgment. If only 5 days before judgment, counsel sought to halt the proceedings by asserting that constitutional interpretation was necessary, the trial judge was entitled to inquire whether the alleged constitutional issue genuinely arose from the proceedings or whether it constituted an attempt to delay the conclusion of the trial. Timing alone does not determine bad faith, but it is a relevant factor in assessing whether the application is bona fide or constitute an abuse of process. Article awatron, very beautiful, nice, magnificent article. Utie nsemu awoka eto asumu. But the name sema tuja. Or say yes. Eni kwan say ka say time no mo ba be ye we nti. But ni nemu no ye hwe nsem ni mu a say judge na wode ne nyansa etena asem ne so. No wo hwe no hu ne se da bi asem we de. Eye delay tactics ana say eye genuine. Or say the trial court therefore retains jurisdiction until it is satisfied that Article 130 has already been engaged. Jurisdiction is not automatically ousted merely because counsel announces an intention to seek constitutional interpretation. Rather, the court must first identify the precise constitutional provision requiring interpretation, determine whether that provision is genuinely ambiguous or uncertain in its application to the facts before it, and decide whether the case can be resolved without resort to constitutional interpretation. Only after satisfying itself that a real constitutional controversy exists does the mandatory obligation to stay proceedings arise. If no such issue exists, the court is perfectly entitled to dismiss or refuse the application and proceed to deliver judgment. Or see, the position is equally supported by general principles governing abuse of judicial process. And it goes on to say, Ghanaian courts has consistently recognized that judicial procedures should not be manipulated to obstruct or delay justice. Constitutional procedures are intended to safeguard constitutional supremacy, not to provide litigants with the procedural weapons to postpone inevitable judgments. Accordingly, where the court concludes that an application for constitutional interpretation is frivolous, vexatious, speculative, or merely tactical, it may refuse the application and continue with the trial. The constitutional jurisdiction of the Supreme Court must never become an instrument for frustrating the orderly administration of justice. From the standpoint of criminal procedure, once both parties have closed their cases and filed their respective addresses, the trial enters the judgment stage. At that point, the judge owes a duty to determine the issues before him within a reasonable time. Although a court retains discretion to permit additional written submissions or grant reasonable adjournments where fairness requires, that discretion does not extend to permitting endless interruptions founded upon unmeritorious constitutional objections. Criminal justice requires both fairness to the accused and timely determination of criminal proceedings. Also, accordingly, on the facts presented, the better view of Ghanaian constitutional law is that the trial judge is not compelled to suspend the judgment merely because defense counsel alleges that constitutional questions have arisen. Si ye bra nsɛm a wɔka ne tentene ne tietie mu nyinaa ne sɛ ɛnyɛ ɔhyɛ sɛ ɛyɛ Chairman Wontumi lawyer aka sɛ yɛpɛsɛ yɛkɔ Supreme Court nti no delay case no mema ruling no ɛnyɛ ɔhyɛ sɛ wɔsɛ judge no ɔfoa so ɛnyɛ ɔhyɛ nyɛ by force ɔpa ɔbɛyɛ ɔpa ɔnyɛ asɛm ne tentene ne tietie mu no. And so our brother, the article is quite lengthy. Anyone who wants the article on WhatsApp, you can just send me a WhatsApp and tell me, say, Melodies, let me get the article, right? You can get the article and read the article. Very, very good article. And you see, I like this. I'm not going to lie. I want us to, be doing things like this. I know that a lot of people, a lot of professionals listen to me. I have lawyers listening to me. Some of you reach out to me. I have, business consultants, business strategists, people. I have omo dealing in gold and all that. I have a lot of people listening to me, and sometimes you reach out to me. Mr. Remo, what I want from you, and they say issue be ba na unim say issue no your sector. Now you have an idea on it. You can write an article like this and send to me on WhatsApp. I personally believe it's one of the ways I Ghana and able to me Ghana. And so if you are listening to me and you are a contractor, near see road issue biaba now person throw BB fan write an article like this and send to me. I'm going to read, And then Ghana say, yeah, kasa about flood. Now Osha, we a civil engineer. Minyama bi wo hɔ a ofio say betumi aye na amasa flood yi aya won kran yi akofom a very simple. Just write an article, put the things. You never know who is listening. You never. There are a lot of people who are listening online who are not even reaching out. A lot of people in governance and all that who are listening online who probably might not even be reaching out. What you say? So I'm giving you this opportunity. If you are a professional in a field, na mo ho asemba o ye sofo mpo na o hwe na se asembia ba na trendy na asosofo no o pese o tre wa adwen wo so a please write an article fabra mebo udin so o pese me tre picture kra me tre picture o pese me do number to me do number be to I want to be encouraging things like that. I am happy when we write about issues in this country and then we are all reading and getting to get the view. That is what I want us to encourage. Right? Let us get the professionals to be speaking on, technical issues. That is how the country is going to move forward. So this is my official invitation. Whatever you want to write on in your field, if you're an investor, you want to write on the investment scene in this country, write an article, send it to me, let me read. Let people get to know you and all that. That is how the country is going to get better. And our brother goes ahead and then gives a year leading Ghanaian Supreme Court authorities on Article 130 of the 1992 Constitution, referral of constitutional questions. And so he goes ahead to give cases or they supporting the arguments. Cases no, a be a to 4 versus Attorney General in 1980, Nansia, I say Republic versus Edubuahin and another. The Supreme Court explained that Article 130 is activated only where a genuine constitutional question actually arises and all that. It goes on, I say Republic versus High Courts, ex parte Attorney General, Balkan Energy Ghana Limited and others interested parties. It goes on, all the cases be or they supporting the arguments. And I love this. I'm sorry, say because of time, I cannot read the entire, article. Into Daniel Gidi, law student, Faculty of Law, Greenfield University College, Sunyane, Atiasie. You can also write, or if you want to read the full article, you can just send me your WhatsApp. Send me hi on WhatsApp. My WhatsApp number is 055-807-4986. Or if you want to write an article on your field, if something is going on in this country, you want to write an article, just write the article and then send me on my WhatsApp, and then I'm going to, peruse and then read. Montreal your comment box nimo medasi. Ghana ni bia wutie me no. Book we eye asset ba ko a e wo se wo keep e wo fie. To book we ma wo ho. To ma wo ba. To ma obi biara osumbo e wo wabrabo mu. Wadamfo obi a opese odi ye wabrabo mu bia no. To sa book we your friend the Ghanaian investor. Na sa book we be trail different forms of investment a obetumi aye e wo Ghana ha. Licensed investments. The first one e ya de bia your friend emergency fund. Book we bet show send you set up emergency fund. Abrabo aye boy bibia betumi ato. If you have an emergency fund, ebeba na aba be save you. Oka betumi asay wo kwan so. Obetumi ayare, oba betumi ayare, nini na emergency fund no ebe take control of all those situations. Book no besan so atre wade bia ye fe na endowment fund. A obetumi dia protect you ho any your future. Na sa endowment fund no nyame mpengu ukokonya accident na untumi nye adwuma bioma, it will take care of you for the rest of your life. Book no besan so atrel send ya obe set up a personal pension fund.
Nkrofo bebre eye adwuma wie ekọ retirement omo retirement we are no mo ho aba betwe omo o set up a personal pension fund. That will not be your case. Most importantly, book we betwe how to invest in the Ghana Stock Exchange. Now Ghana Stock Exchange investment, basically, it means you are buying ownership of Ghanaian companies. Now Ghana Stock Exchange, it is one of the best performing markets in the whole world. A lot of people are making money from the Ghana Stock Exchange, but they don't know how to invest in it. Book we a better idea. Your investment be why a friend of mutual fund. Book we better how to invest in a mutual fund. Now mutual fund, you don't need to be rich to invest in a mutual fund. I remember an example. You find say wa woba fresh. Now what per license mutual fund Ghana has say opesodi usikashim. Say Wontumi invest 500 cedis every single month. A Ghanaian mutual fund moi. By the time I will be 19 years now I done a millionaire. You find say wa fasibi we did 10. Opese that chibi odiye. Every month for 500 cedis a mutual fund boom emano. By the time I will bano and I will fast obedi 29 years now oye millionaire. Wankasa utie me we di 40. Now so washa unye investment biya and no one say obeye mutual fund every month for 500 cedis a shame. By the time obedi 59 years now when you 1 million Ghana cedis. Into mutual fund that is how it works. Small money every single month. By the time embre ebebano nesikano ayekese book we better sanya mani na sa ope book no ni PDF anase ni twi video a free anase WhatsApp number na ewo book ni so sisia na sa we Ghana ni na wa brochure na ope hard copy of the book a very simple call Amazon na search for the Ghanaian investor place the order bibia obi a be ship e dia bro medase.